Welcome to Inherently Distinctive.
Welcome to Inherently Distinctive with attorney Mark Goodman, your go-to podcast for protecting innovative ideas and brands. I'm Zofia Morales, and today's episode is Who Owns Your Trademark? Legal rules every startup founder should know. Welcome back, Mark.
Oh, I'm thrilled to be here as always, and once again we've got a very nuanced topic here, so it'll be good to do a deep dive on this. It seems so simple, doesn't it, Sophia?
It does. I mean, the whole question of who's the legal owner of the trademark, is it the person, the business, or both?
So, legal owner of a trademark, really, it's about the entity that is selling product or service to consumers, right? When we talk about,
Okay.
so, and you don't have to have a corporation. Most people do have a corporation or an LLC typically, right? If you want to be a sole proprietor and just sell products, you own the trademark, you can do that. I don't recommend that, right? That's it.
What are the
you don't have,
pitfalls there?
and it's really not so much of a trademark issue. From a trademark point of view, if you are a sole proprietor and you're running a business and selling, the ownership's clean, right? That part's great. The problem is that if there's liability, your personal pocketbook, right? If Sophia's out there selling Sophia widgets, you don't have a company, right? Then let's say somebody, so say somebody swallows one of the widgets, right? And there's some medical problem, right? It has to be surgically removed, right?
They are not intended to be swallowed,
not
people.
only sue Sophia Widgets, the business, but they can, whatever personal assets you have are on the hook for judgments, right? Whereas if you had an, Sophia Widgets LLC set up and you were selling through that, then, hey, worst case scenario, they could take all the assets of that business, which is not good, but at least your personal wealth is not at stake here. Right?
Yeah, I've still got the house and the car and the retirement
that's a
account.
big deal, right? So
yeah.
yes, that's one consideration, right? And so no, but if you are selling this is where you can get messed up on the trademark side. Let's say you do have Sophia Widgets LLC. Please, let's not file your trademark in your own personal name because you're selling through the business here. This is a potential problem. There is case law that basically states, right, case precedent says that if a trademark application is filed under the wrong name, basically wrong owners identified, that trademark application is void ab initio, which is a Latin phrase that means from the beginning, right?
Like
so
from
the
the
get-go, it's like it never happened. Like this thing is just disappears. Right?
Oh. So you can't fix it. You can't file an amendment or sell it to the company.
It's one of the biggest pitfalls actually in the trademark practice. Now you can, I suppose. I mean, I thought about this because it's given me some heartburn in certain situations with folks coming in.
I'm sure.
If you're selling product, you have rights under the common law, right? Even if you don't have a registration, so I think still have those. But then you've lost all the benefits of the trademark registration, which are very powerful. If you're just at the application stage, I'm working with this with a current client actually, where there's a possible issue of a misidentified owner. And the examiner even said, if it's this application is going to be thrown out because it's void, right? But I've talked to the client, well, if that's the case, I'd rather know now rather than try to enforce it because we can file another application. Right, and get it right the second time. So you do have that. Whereas it can be much more fatal if you're in a position where you've gone for years this way and you're suing some evil infringer competitor, and then they come back and say, actually, your trademark's void. And that
would really stink after you've been doing this for 15 years.
Okay, so war story now, right? Client way back, this was about 12 years ago or something like that. My client had a certain trademark. That trademark, we got a petition to cancel that mark from a very large company that you probably would have heard of, right?
Wow.
And that company, it went back and forth. And one of the big issues in trademark law, the first was they were claiming that, well, we've used this since the 70s. For some reason, we didn't get the trademark on it, which is very surprising that a large, fairly well-known company would just blow through this and not get a trademark registration on a pretty important brand to them. But
Right.
it happens. These big businesses are not perfect, far from it, right? So,
Right. The
right.
left
So
hand doesn't know what
they
the
didn't
right
have this, and
hand's
then
doing.
all of a
Yeah.
sudden they woke up like we're talking from the 1970s through this case was in the early 2010s, right? They're like, well, we've been doing this,
40 years later.
and this was hard because it was hard for me to describe to my client that yes, they might actually win because it is true that first use can trump first to file in the United States. This is not true everywhere in the world, but you still want to file first because this company had all the burdens
Yeah.
of proof burdens on them to prove their case. But then it also came up, they started digging in and taking people's depositions and so forth. It turns out like the trademark, and this was not a trademark I filed, this was one they came in and they had done themselves or something like that, was actually filed in the name of like the son of the owner of the company. What? Why are we doing
What?
that? Oh, well, I thought it would be
Yeah,
great
good
to put it in
question.
his name. I can't even remember the reason at this point. It's been too long. I was thinking, what are we? So then they took the position that it was void under this case law, right? Oh, that
Yeah.
was
Oh,
a
yeah.
not a nightmare.
That'll give you an ulcer right there. So, do you sometimes see where there are ownership disputes that arise between like founders and partners and employees on something like this?
Here's the thing is trademarks are about branding, right? So unlike with patents, I think with patents you'll see this more because you may have somebody invent something and say that, well, I actually invented this on my own time outside of business hours
Right.
and what you're paying me for, that kind of thing. Um, Whereas at least with trademark, it's about the brand in the marketplace. So you don't see it so much internally. At least I haven't seen that, but I'm not saying it can't happen. But what I do see a lot of is again this issue of with people that are flying by night on their trademark applications. If you don't get the ownership right, it can really really mess things up, and that's why we're doing them. It's like that's the part I go the slowest on. Okay, what company? One practice I have, I always, at least for a long time now, I've always downloaded. If you have a company, an LLC, corporation, I always check it. Right? Is this company still active? Right? Right? Is it not like,
Right.
because sometimes people have these LLCs and it gets revoked and it's been revoked for 3 years and they still think they have
Yeah, administratively
it, right.
deactivated
Yeah,
or
or
whatever they
eventually it's
call it. Yeah.
permanently revoked, or each state has their own laws on this stuff. But so I always pull down from whatever state you're incorporated in, what your um, Secretary of State's current printout is on your company and put that in
Status.
my
Yeah.
file for my due diligence slash CYA purposes, right? To make sure, okay, now, and then confirm this is the company we're using, right? Okay, right? This is the one that's selling the product in the marketplace, right? Okay. And that's how we want to file it. So, yeah, I think it's more of just getting things messed up than internal conflicts, I think, although I'm sure it happens out there. Everything happens. And eventually it comes into my office.
Yeah,
So, probably.
Okay. So let's say that there's been some choppy waters, right? And maybe the original LLC had to file a bankruptcy or something like that. And you need to restructure. You're going to spin out and do this thing in a different corporate structure, for example. Can you transfer your trademark to that new company
So
or
here's the
that new
thing, on
entity?
paper, you can always transfer it, just like with patents or copyrights or other things. In fact, the trademark office has its own recording system. So it's almost like recording a deed. Very, very similar to that.
Mm,
Except quite frankly, it's better because I think the trademark office's system is smoother than deed recording systems in most counties I've worked with doing that in the past. But anyways, so you have this very clean looking system on the surface. However, trademark is all about branding, right? So any trademark assignment can be challenged later by someone saying that assignment was a quote naked assignment, right? You assigned the name over, let's say, but the actual business goodwill didn't, right? Now, of course, and it has to actually go over. I mean, I've had this. I got tangled up in this once last year, and there's an issue of like, okay, my trademark assignment said all the goodwill is hereby transferred to this other entity, but someone else was trying to say, and this ended up being resolved differently, so we didn't really fight all the way. But what they were trying to say is, look, you may have said in the document that you transfer all of the goodwill of the business from this entity to this entity, but you didn't actually do it because this other company, the one that transferred it, kept using it. And this other company didn't. In other words, has to be real world, not just on paper when you transfer. That's
Right. So the company that
the,
gave it
yeah, the
away
one
has to
that
stop using
assigned
it,
it
and the one that
kept
received
sort of
it,
using it for a
yeah.
while. It was very informal and flaky, right? Like what you need to do is make sure it's clean. Like, okay, this company is using this trademark in this field. Right now, we assign it. Now everything is going over. The goodwill is owned by company B. Company B now is using it. Company A better not be using this anymore if we're assigning.
Mm-hmm. Wow, that sounds like it could become a real mess real fast. When you're dealing with freelancers and contractors, as you tend to do when you're starting up, um, what are some of the pitfalls? Should they ever own part of your IP? Are there ways that you could accidentally give away your interest in your IP?
So, okay, let's address each of these questions. So, should you have freelancers or contractors own part of your IP? I don't think so, right? I can't really think of too many scenarios where that would make any sense at all. I mean, I guess the thing you might be thinking about is, well, if you have absolutely no money to, to start out, you could offer equity in the project in exchange for people working on it. So,
Right. Yeah.
you know, I just think that it could get very messy when you do that. So I don't really recommend it. But I also understand that if that's your only way to get a certain thing done, maybe you could do it. But you better really trust the person that you're dealing with because it, again, could be very, very messy much later on. If the project is successful, because now somebody that
Yeah.
did like what would have been $1,000 of work is now going to be claiming $1 million worth of equity in this project. So you'd have to really document it well if you're going to do that. Incidentally, people ask me that all the time, right? If I would take a piece of this invention, and again, it's one of my excuse, which is always good, is that the insurance companies, the malpractice insurance companies, don't want me to do that, right? It's legal for me to do that, actually. I
Yeah.
could do that as far as my bar ethics, as long as it's like well documented. But the insurance, they ask me, and so I'm hesitant to do that.
Don't.
Um, in general, at least, right? It's
Yeah.
different if maybe I have a long-standing relationship with someone, you know, and you're actually wanting to go into business with somebody. But generally speaking, just don't do that.
When you're talking about contracting out work for hire, that sort of thing, what should you be aware of when you're making those contracts so you don't accidentally give away IP ownership?
Well, I think most important is just to have a written agreement between yourself and the contractor. It doesn't have to be like super complicated, but it should state that you retain all ownerships of intellectual property that you have, and that any intellectual property that the contractor or freelancer develops is owned by you also. That would be your ideal situation, because both can be an issue. One could be you disclose things to them, right? Another issue is like, well, if you're paying
Right.
somebody to create something, you want to be the one that owns that, because otherwise, why are you paying for that? And the law will save you in some circumstances, but not all circumstances. So it's best to also have that written in a contract that's signed by both parties. That's best practice.
So, what is your final words of advice for founders to avoid these kinds of messy IP, branding, trademark,
Um,
patent
I would
disputes?
say take ownership of your intellectual property seriously, right? It's not something that is going to take a lot of extra time or cost a lot of extra money to get right in general. But if you just act haphazardly, you can completely mess things up. So it's just something, talking to some intellectual property counsel early on in your venture, well, let's address this. Who's going to own what and why, and call balls and strikes on it.
Very good. I like that. Thank you for sharing your wisdom today, Mark.
Yeah, anytime for you, Sophia.
All right. And thanks for listening to Inherently Distinctive. Make sure your trademarks are protected and correctly assigned. And if you're not sure, reach out to Mark at goodmanlawnevada.com. And make sure to follow, subscribe, and review the show if you found this helpful. And stay tuned for the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.